Hello everyone, today I'll be sharing another legal story with you. So what happened on 10 September 2025 is that the Supreme Court of India was dealing with the case of Muhammad Russell C and another versus the state of Kerala and another. Okay, so while the Supreme Court was dealing with the case, basically what happened in this case was the petitioner he directly approached the Kerala High Court for the anticipatory bail without first approaching the sessions court. So what the petitioner has done is the petitioner has bypassed the sessions court and has directly approached the Kerala High Court seeking the anticipatory bail. Okay, and regarding this, the Supreme Court has expressed disapproval of practice of High Court directly entertaining the anticipatory bail applications bypassing the Sessions Court. So Supreme Court has expressed disapproval regarding this practice of High Court directly entertaining the matter bypassing the Sessions Court. Okay, and the court has decided, basically the Supreme Court has decided to consider the appropriateness of the practice, and in regard to that has issued the notice to the Kerala High Court. So the Supreme Court has decided to consider the appropriateness of this practice of bypassing of Sessions Court and directly approaching the High Court for anticipatory bail. So the Supreme Court is considering the appropriateness of this practice, and in order to consider that appropriateness, they have sent and basically they have issued notice to the Kerala High Court regarding this. Okay, this is what the present scenario of this case is. Okay, so presently the court has issued notice. This is the present scenario of this case. Now let's discuss what the bench while hearing the case acknowledged. What do they point out, right? Let's discuss all those things so that we can understand and have a view upon this practice, whether that is appropriate or not, right? So we should have our own view also. So let's discuss what the bench has acknowledged regarding that. Okay, so the bench of the Supreme Court acknowledged that the fact that the BNSS has provided concurrent jurisdiction to both High Court and Sessions Court. So basically the Bharatiya Nyaya Suraksha Sanhita and the CRPC, they have provided concurrent jurisdiction. BNSS under section 482 and CRPC under section 438, they have provided concurrent jurisdictions to both the Sessions Court and the High Court to deal with the anticipatory bail applications. Okay, however, the bench of the Supreme Court is of the opinion that High Court can entertain anticipatory bail matters directly in exceptional cases only, and that too after recording reasons. So the bench of Supreme Court is of the view that the High Court should entertain, even though the BNSS and CRPC has provided concurrent jurisdiction, but the Supreme Court bench is of the view that the High Court should directly entertain matters only in exceptional cases, and that too after recording reasons. Okay, the bench was of the view that if anticipatory bail applications are directly allowed to be filed in High Court, the court will be flooded with such applications and would create chaotic situation. Okay, so if we allow the filing of anticipatory bail applications directly into the High Court, it will overburden the court and it will create a chaotic situation. Secondly, the bench also noted that the session judge can exercise their power under section 482 of BNSS or section 438 of CRPC in relation to all cases registered in a police station within a particular district. So the Sessions Court or the session judge has the power to entertain all the matters that are registered in a police station within the particular districts. Also, the area-wise distribution of work would make it more convenient and facilitate expeditious disposal of the anticipatory bail applications, right? So if the Sessions Court, if they entertain the anticipatory bail application, then it will help in expeditious disposal, right? How and why? Because see, the Session Court have the direct first-hand assistance of the public prosecutors appointed for a particular district. So they will get the first-hand assistance of the public prosecutor. Okay, secondly, they have immediate access to police diary, which will facilitate better appreciation of the facts of the case, right? This both the things would help the session court in disposing anticipatory bail applications expeditiously. That is why the bench is considering that even though concurrent jurisdiction has been given, the first hand matter should be dealt by the session court itself. Okay, the court's decision in Arvind Kejriwal versus Directorate of Enforcement made position clear that it would not be necessary for an accused to approach the sessions court in first instance as a rule before approaching the high court. So in Arvind Kejriwal, the court already said that the position cleared its position already, that it is not necessary to directly approach the session court in first instance as a rule. So there is no said rule that you have to first approach the sessions court and then approach the high court after that only. So there is no said rule as of right. You can directly approach the high court as well, but the present bench in this case of Muhammad Russell C Another versus the state of Kerala and Another, they are considering that the petitioner, he should not approach the high court directly because of the following reasons that we have discussed. Okay, so let's wait for further updates on this case, right? What does the bench says, what is their opinion? Let's wait for that. Okay, so this is what happened in this case till now. Presently the bench has issued notice to the Kerala High Court because they want to consider the appropriateness of this practice of directly approaching the High Court, right? This is the present scenario that is happening. Let's wait for further updates too. Okay, thank you so much.